Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about confidential informants. Cases that should have gone to the Supreme Court of Canada, but didn't. Agent E provided information to the RCMP over several years related to the activities of criminal organizations. The RCMP did not compensate Agent E for any of the information that they gave to the RCMP in order to facilitate investigations of criminal organizations and unlawful activity. Agent E ultimately ended up suing the RCMP on the basis of an allegation that the RCMP had been unjustly enriched by the activity that Agent E had engaged in, and that Agent E was entitled to compensation, that effectively a contract had been formed by the provision of the information that required the RCMP to disseminate payment to Agent E on the basis of the work that they did. Agent E lost in court, appealed the decision, lost at appeal, and took the case to the Supreme Court of Canada, which, of course, denied leave. And this case is a very important issue because individuals provide information to police all the time, and it raises the question of how much information does somebody provide to the police before their actions go beyond just merely providing a tip or making a report to actually working as an agent of the police, providing the police with investigation information that can allow them to facilitate their duties, and opportunities for funding to carry out investigations, opportunities to seize assets like cash and houses and cars, which are then sold for the purposes of facilitating government profits. If the agent is providing sufficient information to allow all of these things to take place, is the state not unjustly enriched by the activities of this individual without compensating them? But also, on the other hand, does compensating individuals for providing ongoing information to the police potentially compromise the integrity of that information by making them motivated to provide information and more likely perhaps to distort the information? Is it less useful in the investigative process because of how defense counsel might deal with it in an ultimate trial because the information was bought and paid for? These are important questions, and they're the types of questions that the Supreme Court of Canada should have answered. It obviously raises issues that have application to civil forfeiture proceedings, to criminal proceedings, and to contract law in Canada. And it's very rare that we see circumstances involving all three of those things together in one case. And the application of the principles with the background of the nuance of providing information against individuals who might potentially be dangerous and putting, therefore, their life at risk by providing that information, doesn't that necessitate some commentary from the Supreme Court of Canada on this? This was a missed opportunity for the Supreme Court of Canada to really get into the nuances of confidential informants, their work and their contributions, and to provide value to that, which might actually encourage more people to come forward with other information in other cases, and may ultimately make the work of the RCMP easier. It's going to take another case where somebody has seriously stuck their neck out to provide information to police in order for these issues to be once again considered by the Supreme Court of Canada. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.